Mesan so Emma obi biara akwaba bi mede ba en channel kesi so bi so anya subscribe ya mesrɛ na we mia subscribe button no so e de amana de koso e o man kronkron Ghana na ba e de bi betuma wo so anya bi no ahwe wo nsira betu e wa na na busu ansema horo a e koso e o Ghana no se no ano e de yɛmfa ani enkyirem o ye parliament na te se ne press conference bi e koso on man na te se enye asanketo akra kwame na atoforsen any na be de chi na te se minority leaders any mpinfo ho no etimi some meeting kitwe bi na te se enye asanketo akra meeting a omo ye ni na e kire se NDC amanyokuo no any na be de chi for e kire se enyoma omo ahyehye e de etia minority leaders no any minority na nkasa no so no ebusua eno ho asem e na omo ka e wo ho no na te se enye asanketo akra omo de details ababeto emonten so e fa enyoma omo susu se NDC amanyokuo His Excellency John Dramani Mahama ya omo nti ase ade a obu omo ye pa onfa omo nye hwe ho ma na te se ebusuan asem no areho na ebusuan menya audio saworo bi wa ase na te se me se o no ibekwa kwaji nchire mu.
This emphatically and without equivocation, the minority will lawfully resist any attempt, whether subtle or brazen, to bar him from representing his people. We will not permit democratic legitimacy to be overturned by judicial improvisation. The factual background. In December 2024, Honorable Matthew Nyindam was duly declared Member of Parliament for the Pandai constituency following a peaceful and orderly election. His opponent subsequently filed a petition challenging alleged irregularities in 41 polling stations and aspects of the collation process. The relief sought by the petitioner himself was clear and specific. He requested rerun in those 41 polling stations. And by the way, he had prior to the gazetting of the results filed a petition. And when counsel for Mr. Honorable Nyindam raised a preliminary objection and same had been argued, and the very day the judge was to determine the matter, they quickly filed a notice of withdrawal, which was quite strange. This judge, who knows that when matters close and he's fixed a date for judgment, no matter what, he's supposed to deliver a judgment, decided to stay away from determining the matter because a party has decided belatedly to file a notice of withdrawal of the case. Yet, in a development that defies ordinary legal reasoning, the High Court issued an order directing a full rerun of the entire Pandai parliamentary election, covering all 152 polling stations, to be completed within 30 days. As if this judge is not aware of the Supreme Court decision in the Akufo-Addo and others versus John Dramani Mahama and others in the 2012 presidential petition. The sad part of it is that the NDC candidates and his supporters were aware of the judgment before the day, to the extent that on the day of the said judgment, the regional minister led a team of NDC party faithfuls into the courtroom, anticipating the expected result, the result that they were going to have judgment in their favor. The judge, who spent minutes, walked out of the courtroom claiming that his judgment will be ready on Friday. Meanwhile, in less than 24 hours, a court order was being served on Parliament and Honorable Nyindam. What kind of kangaroo judicial system we are having now in Ghana? The judiciary must know that their actions and inactions to serve the interests of whoever their paymaster is has the tendency of destroying our peaceful republic. We will not mince words. They can conspire to call us one by one for a so-called contempt of courts. We are criticizing their shameful conduct, we are not afraid. We are ready to be in Nsawam for their so-called contempt. The world will see their disgraceful conduct. We will not sit aloof and allow them to undermine the very rule of law that they are supposed to protect. How can a judge who calls himself a judge sit in court and misconduct himself in such a manner and expect the country to be quiet? Now here is where the matter becomes even more extraordinary. This order, an order with massive political, legal and democratic consequences, was pronounced without the court's full judgments, as I've stated supra. There were no written reasons, no factual findings, no legal analysis, just a naked directive issued into the public domain. And the whole constituency is now being told that there must be a rerun. I am a practicing lawyer of experience at the bar. I understand that courts occasionally deliver rulings with reasons to follow. But such a practice is the exception, not the rule. And it is never acceptable approach when the stakes are this high, when a parliamentary seat hangs in the balance, when constitutional rights are imperiled, and when the vote of thousands of citizens face annulment. For a judge to casually void an entire constituency elections without first ensuring that a complete reasoned judgment was prepared and published is not merely irregular, it is judicial irresponsibility of the highest order. We have carefully reviewed the relevant authorities, including the Supreme Court's decision in Kojoba and Ghana Water Company Limited and another. In that landmark case, the court affirmed a long-standing principle, quote, in the interest of substantial justice, a court may, in limited and carefully circumscribed circumstances, grant relief not specifically sought by a party, but only where such a relief is unmistakably supported by the pleadings and evidence, causes no unfairness or surprise, and brings true finality to the issues properly before the court. Let me emphasize, this is a narrow exception, not a judicial blank check. The Supreme Court made abundantly clear that such power is to be exercised only when, one, the parties have had a full and fair opportunity to address relevant issues, the evidence unequivocally supports the alternative relief, and three, there is no element of surprise, prejudice, or procedural ambush. Now, ladies and gentlemen, none, absolutely none of those conditions exist in this case. The High Court order is not a principled application of the Kojoba doctrine or any other known doctrine. It is a brazen abuse of it, like the judge who invoked the animal farm to remand Abronye. Consider the following facts. One, the petition did not plead irregularities in all 152 polling stations. The petitioner did not lead evidence concerning 152 polling stations. The parties never argued about 152 polling stations. And no one, neither the respondent, nor the Electoral Commission, nor the voters of Pandai, was put on notice that the entire constituency election was at risk of annihilation. In fact, the key witness to the petitioner underscored the fact that all they needed was a rerun in some 41 polling stations. He again added that the collation was done without due notice to him. Has the judge read the CI? Has the judge listened to the Electoral Commission regarding the violent conduct of the petitioner and his followers, leading to the termination of the collation at Pandai and eventual transfer of collation to Tamale? Indeed, this is not substantial justice. This is substantial injustice, a textbook case of judicial overreach masquerading as equity. Let me be clear. We do not accept that the petitioner proved his case. But even if he did, the court found credible evidence of wrongdoing